Why setting up an estate plan is essential for parents that want to pass on their home to their children. This is estate planning lawyer Michael Pevney, and I create estate plans for families in California. If you get some good information from this video, please like it and follow this page for more estate planning information. Now, a lot of times I get inquiries from kids whose parents the kids have taken over the mortgage on, and they say, well, I've started paying my parents' mortgage. They're going to pass the house on to me. So how do I actually get control of that house? What happens when they pass away? Well, you've got to get yourself on the deed to that house one way or another, and the best way to handle that is to set up an estate plan, oftentimes a trust, a revocable living trust. And this is really essential if the parents have more than one child and they want to pass that home along specifically to one of the children. Maybe one of the children are already living in that house. The house is still in the parent's name, but the child is paying the mortgage on that. Because there's two different things, right? There's a mortgage, and a mortgage is just a loan that's backed up. It's a secured loan that's backed up by the home, meaning that if the mortgage isn't paid, the bank can foreclose and eventually own that home, auction it off, pay themselves back. Now, the deed or the title to the property says who actually owns the property. So if parents are on the title and have never changed title to the children, the parents still own that home. And that means they can do whatever they want with it. They can take out another loan, they can give it to somebody, they can sell it to somebody, they can rent it out. Even if there's an understanding between the parents and the kid that the child is going to pay the mortgage and then the house is eventually going to go to them. Not necessarily so unless there's a specific estate plan in place. Now, for several reasons, I think it's a bad idea if parents intend for kids to take control of a property once the parents pass away, to put the kid's name on the deed while the parents are still alive. That could cause an increase in property taxes, especially if the child doesn't live there, especially in California. Property taxes are such a huge deal. It's based on the value of the home at the time of a deed transfer. We really want to avoid a reassessment in taxes. That can easily happens all the time. Property taxes go up by like $10,000 a year. It's a messy situation. And then when it comes to capital gains taxes, once the parents are gone and the children might want to sell that house, there may be an increase in capital gains taxes. So from the parent's perspective, I typically do not recommend putting the child on the deed to that home, because that can cause those two things some fluctuation there in both property taxes and then way down the road capital gains taxes. The best way to assure that one child or a specific child actually gets control of that home once the parents pass away is to set up a complete estate plan. And that usually involves a trust, a revocable living trust. So what we do is we put the home from the parent's name into the trust, and the trust is controlled by the parents until they're gone, until they've passed away. They are the trustees of the trust, meaning that they have complete control over the trust and everything that's inside of that trust. But then once the parents are gone, the rules of the trust dictate, and it may be as simple as, after we pass away, we bequest, or we give this house to this specific child. And I'm going to reiterate again, this is especially important when there's a child paying a mortgage on a home owned by the parents, or there is more than one child, because if there's more than one child and there's no estate plan, that house is likely going to be split up. One child's going to have to buy out the other. A lot of times it causes people to be at odds with each other, and it causes a lot of family strife. So we want to put the home inside of a trust, a revocable living trust typically, and then once the parents pass away, we have to follow the rules, the terms of that trust. And then what that is going to avoid is that increase in capital gains tax and a premature increase in property taxes. And I'm specifically talking about California here because property taxes are such a mess. So just because you're on the mortgage to a home, just because a child, even if they are on the mortgage or on the note or on the loan, doesn't mean that the home belongs to them. You have to look at the deed, at the title. and that's all publicly available in county records. So if the deed has not been transferred to the child, that home is not going to be in the child's name and may never be in that child's name fully until long after the parents have passed away, gone through a long probate process. The better solution: get the house in a living trust and spell out in the living trust exactly what you want to happen. If you have any questions about deeding homes to a living trust, kids being on the mortgage, or anything else related to estate planning, you can go to my website, ocestateplanlawyer.com. You can set up a time to meet with me for free. I do free meetings for California residents. It's a $400 value. Thanks for your time, and thanks for your attention.